It now being 7 o'clock, a quorum being present, I will call the regular meeting of the Zoning Board of Appeals of the Town of Orleans to order. My name is Michael Marnick. I'm the chair of the Zoning Board, and with me is our regular members, Matthew Cole, Beth McCartney, Ralph Soderstrom, and Associate Member William McCarthy, all of whom were present at the earlier hearing in case number 1974. An item of housekeeping, it would be in order to approve the minutes of the meeting of December 4, 2013. And I so move. Is there a second on the motion?
Second.
And is there any discussion on the motion to approve the minutes? They're failing that. All those in favor?
Aye.
And opposed? Motion carries unanimously. Also present at this hearing is the Board Secretary Sandy Stewart and the Building Commissioner of the Town of Orleans, Brian Harrison. Mr. Riley, so let me, as a predicate, have any members of the board since the first hearing been subject to any facts or circumstances which would now create a conflict of interest, which would make your participation in this hearing inappropriate? No positive response, then I continue to declare that the members of the board are impartial. Mr. Riley, since the hearing, you, at my request, have submitted findings of fact in a couple of documents. I think what I'll want to do first is to make sure that the record is complete, that you and everyone else at this hearing knows exactly what the board is considering. We have an application, case number 1974 by Mr. Simon, filed November 1st, 2013. We have a plan. I'm going to, portion of a plan. I will mark it Exhibit 1. Dated on or about November 1969. 68, excuse me, recorded in April at the Registry of Deeds, the Herdick plan. I have marking as Exhibit 2 a stapled series of exhibits, including the plan I just referred to, and a series of documents, except for the last one, related to proceedings by Hertig and McLucky in earlier than 1982. That included the decision of the zoning board in case number 806, dated April 20th, 1982, and filed with the town clerk and the Registry of Deeds, for that matter. The last 2 pages in this package, Exhibit 2, are what appears to be a building permit application. I think this is dated,
I think it's the year 2000.
I think it's the year 2000. It seems to be undisputed that's the year 2000. No date appears upon it, but it's 3 pages, excuse me. I have,
I think the significant date would be the date of the actual permit, which Mr. Harrison has, I know.
okay, I am also, yeah, let's take a look at this. I have also a 2-page plan, a portion of which is titled Site Plan.
It's a separate.
That's
You know, maybe there's 2 of them.
well, that's the Board of Health could not copy the plan as a single sheet, so that's a single plan
Okay,
from the Board of Health. I think it's sort of side by side.
I see.
And and that was the plan filed by Ms. Dennis with the Board of Health.
In 1998.
Right.
Do we have any evidence in connection, what the reason for Ms. Dennis doing that? Probably because she was doing something with the septic system?
Well, what we have, you have the note from Pat Ballo,
Yes.
and I submit that note explains, because that note was attached to that plan in the Board of Health file.
Oh. Then, there are three documents that are together.
Right.
There is a sheet on legal paper which has a note dated August 19th and September 9, 1998, referring to something that Mr. Ballo,
It's Miss Ballo.
Miss Ballo.
Miss Ballo, having spoken with
Myra Dennis.
Myra Dennis and Jerry Ryder regarding the plans for future site development. That's laid over some kind of an application,
It's a septic.
probably a septic
Yeah,
application.
that was the septic
Yeah.
application.
And there's in the bottom, there's a certificate of compliance and a payment of a disposal system, construction permit. We'll mark all of this Exhibit 3.
Great.
I have also a 3.
3 ABC.
I guess I could do that. I'll call it A, Exhibit 3B, and Exhibit 3C.
Can you see the septic?
Yes. And then pass it to me, Mr. McCarthy might think I wanted to see it.
Okay.
I have as Exhibit 4 a email from Michael Ford to Brian Harrison, the building commissioner, dated October 2, 2013.
Yeah, we have that as well.
Okay? And
Thank you.
I have the field card, which would be Exhibit 5 from the Board of Assessors.
Yes.
It's dated on or about September 9, 2013, consists of 4 pages. This is Exhibit 5. And for completeness, I have your proposed findings, Mr. Riley. Your letter dated December 11, 2013, to me, will be in the file, but will not be part of the record. But your proposed findings, will be Exhibit 6. I believe, Mr. Riley, that is complete documentary. Oh, of course. Part of your application was your letter dated excuse me. Part of your application was the denial letter dated October 3, 2013, under the signature of the building commissioner.
Right.
Are there any other documents that the board should be considering other than?
I don't think so. I think that's a pretty complete record.
Okay. And is there any further evidence that you want to present?
No, I'd like to just make a brief statement. I mean, we talked this thing through pretty thoroughly the last time I was here. And I just want to mention a couple of things. First of all, Michael Ford is a very good lawyer, friend of mine. We work together a lot, and we oppose each other a lot. So He's a very competent guy. And I think something that's important for the board members to understand is that, as lawyers, we formulate opinions based on the facts that are in front of us. And so, Michael presumably had the application, the building permit application that Ms. Dennis had submitted to Mr. Harrison in front of him, as well as my letter referencing the Lord case, which is a case from Somerset, Massachusetts. And in the Lord case, it says that if the applicant identifies what they're doing and the permit is granted, in 6 years, the statute of limitations had run, and action may not be taken to enforce the zoning bylaw against that building or use. And I think and I don't know what his opinion would have been had he been aware of the deliberate misstatements that were contained in the application, building permit application that was submitted. And the reason I think that's significant is that in the Lord case and all the other cases that I've seen under the statute of limitations, an applicant requests something and permit is granted. And so to the extent that they ask for something, that thing is protected. Okay. When the statute runs. Here we have a situation where what they said was, we have a thing. Not that we're not asking for permission to have a thing. We have a thing. And we want to put in the windows. So it's not like an application to convert a shed into residential space. And it could be that because Mr. Ford wasn't aware of the, sort of the mendacious aspect of the application, which is laid bare by the note that Ms. Ballo attached to the Board of Health application 2 years prior to that application, where, I don't know if you've read it, I'm happy to read it again. Per Myra, she knows what she wants, to convert house to office, develop sheds into 1 or 2 residences. And yet, when the application came in, it's identified, the structure is identified as a pre-existing 1-bedroom cottage. And so the question before you, and this is an opinion thing. I mean, everybody you have to develop your own opinion of what's right and what's wrong in the circumstance. It's clear that if they'd applied for permission to have a 1-bedroom cottage, that would be protected. The use and the structure would be protected. And so what we're saying is, because of the duplicitous nature of the application, and the fact that they allege that they have the cottage, and our position is that they weren't requesting a building permit for a cottage. They were requesting permission to change the windows and upgrade the wiring. And so what the Lord case said was, even in the face of lies and illegal behavior by the applicant, the structure is protected. So you can't, we're not asking that there be any action taken against the structure. But what the Lord case says is, illegal uses are not protected. And because Ms. Dennis did not apply for, converting a shed to 1-bedroom cottage, I submit to you that the use remains illegal. It was illegal when she wrote it on the application, and it remains illegal today. And because what Mr. Harrison was granting as a building permit was not a building permit to convert, but a building permit to upgrade, to put in new wires and windows and ancillary items. And so because the building permit was not to do the conversion, I submit to you that the use is not protected. And I think that I don't know what Michael would have said, Mr. Ford. I think that if he had been aware of that, that's something that, as a lawyer, or you as a quasi-judicial body, these are the things you weigh when you try to apply the law. And so, sort of, do you reward the behavior by extending the protection? Or do you say, we don't reward the behavior? The building can stay, it can't be used as a residence. I mean, there are other uses it can be used for. It can be used as guest quarters, somebody goes sleep there. But, they can't have a kitchen, they can't use it as a single-family residence. I think that when the whole history of this is viewed from the very beginning, the town allowed it to stay there, and when it should have been demolished, the planning board said demolish it, the appeals board said, okay, you can leave it there, but you can't use it as a residence. Then they caught him using it as a residence, and the building inspector sends a cease and desist letter, and then presumably they stop, because Ms. Dennis, the Pat Ballot, describes it as take the existing sheds and convert them. So, I don't know. I'm good at beating a dead horse, so I can keep repeating myself, but I won't. It's a temptation, but I won't do it.
I wanted to clarify one point. I also admire and respect town council. I believe that the building inspector may have relied upon Mr. Ford's opinion in forming his decision dated October 3rd, 2013, but that opinion of Mr. Ford is not binding on this board in any way. We are entitled to make our own decision on the law or on the facts.
I agree.
Now, I have, and the Lord case is troubling. It's cryptic. I think maybe a more revealing case is Garabedian versus Westland. I'm going to give this to you, Mr. Riley, and maybe while the board discusses it, but I wanted to summarize it for the benefit of all of us.
Okay.
First, this is, it arose in the town of Westboro. John Garabedian went to the town, and Garabedian was a man of substance, a television executive, and his hobby was collecting and flying airplanes. And he went to the town and he wanted to put in a hangar. He had sufficient land. He was able to get to the FAA and get permission to put an airstrip in. That didn't necessarily require town approval, but putting up a hangar did. So when he did that, he called it a barn. But he built a hangar. Years passed, and the neighbors were, there was a venomous reaction between Garabedian and his several neighbors. But to make a long story short, when it got to the appeals court said, look, I mean, there was other issues in the case involving the anti-SLAPP statute because the history of the litigation was so miserable. But the fact of the matter is, Garabedian wasn't able to put up a second hangar, but it was all right for him to keep the first hangar, because even though he called it a barn, everyone could see that it was an airplane hangar, and that's the way he used it. So the neighbors' complaints were time barred. This is probably a better case than the Lord case, and one which, we've got to consider.
Did the statute of limitations come into play on that?
That's exactly what I meant to say. It was,
Okay.
we'll say it's the 10-year statute on uses, or for uses.
Okay.
Mr. Chairman, was it?
It was not a dimensional, which would be a 6-year statute.
Was it Westboro or Southboro?
I think it was Westboro.
Must have been right on the line, because I lived in Southboro, either just after that
Maybe
whole
it
issue.
maybe it was Southboro. It was,
But it is the border. EMC, I think, owns it all now,
yeah,
but.
yeah. So I thought that may have been, I spent some time doing quite a bit
It is-
of research.
It is
and that-
Southborough.
And that looked like a more similar to what Myra Frank Dennis did here in Orleans.
But, naturally, we're all trained to distinguish cases.
That's why I gave it to you.
And the first distinguishing thing is that Garabedian did basically what the people in Somerset did. They said they were building one thing and built another. And that's not the situation we have here. Here they say, we have something, and we want to make minor changes to it. So I think the distinction remains, like this case and like Lord, the structure is protected. The question for you, really, is the use protected? Does the lie on the building permit that says we have an established protected use, that's really what she's saying, because otherwise, she wouldn't need a special permit or a variance to have a single-family residence there. So is that lie protected by the statute? Does it protect the use? And so, with Garabedian, he might have called it a barn, but as the judge said, well, it's obviously a hangar. And so the building inspector, when he went to inspect it, knew it was a hangar. And probably the plane inside might have been a tip-off too, but, here, the building inspector goes to check the work, and, it is a one-bedroom cottage, because, they've already made the change. And so there's no way, for, your staff here to go in and see the lie. There, the lie was so big, the judge said, of course you knew it was a hangar. Here, the lie, by the time the inspector got there, the lie was complete, physically complete. And so, that's why I think this, I say, I haven't bumped into any cases quite like this, where, they said we have an established use that otherwise would be illegal. I didn't find any cases like that. So here we are, cutting edge.
Is there anyone present who wishes to speak in favor or in opposition to this appeal? There isn't. If there's nothing further, then I'm going to close the hearing and...
Mr. Chairman,
Excuse me.
had we concluded the board input last week,
Not really. I don't think we did.
or is that,
I think we'll
I have
discuss
some
it.
questions.
okay,
we can
I
discuss it.
wasn't sure about sequence, okay.
You have a question
Yeah.
of the... Sure.
Well, I don't know if this is permissible or not, but I almost feel like all the buildings on the property should be inspected to see how they're being used. She's got a 3-bedroom septic system that was installed, she's got a 3-bedroom house, and now she's got a 1-bedroom cottage. So has something been changed And did she get permission to hook up the cottage to the septic?
Boy, I'd love to support you, but I think that's an 8-bedroom septic she put in. I think, 8 or 10. I think if you look at that original septic plan, and I don't know that I have it with me,
That plan there said it was for 3 bedrooms.
well, then you may be absolutely right then.
Well, I haven't seen, if there's a plan that says for 8 bedrooms.
No, I mean, that's the plan. I don't have that application here. I thought it was for a multiple. It just looked so big, I thought it was,
So,
Yeah.
and I saw, last week I saw 2 plans. I saw one plan that had the shed slash guest house cottage connected, and one that does not. This plan before me does not. The plan
What?
before me that does not show it connected calls for a design for 3 bedrooms. However, the leaching capacity provided is 776 gallons per day, which would be consistent with a 7-bedroom
Okay.
system.
Uh,
That's why I'm not on the Board of Health. That's why I'm not on the Board of Health.
But I think there is a separate plan
Yeah, I
that
think-
shows
I
that
think there was, too.
connection,
Okay.
and therefore the greater,
Well, the
Well-
original application was for wiring and windows. Was there
So-
anything for plumbing to put in the kitchen and bathroom?
Well, it says
it's for all of those,
Is it-
including
Yeah.
plumbing, but it refers to all as pre-existing.
right, it
This
says
is what
electric
we're-
and
just so
plumbing
we're on the same
pre-existing,
page,
but
just
will
so we're looking
update to code,
Okay.
insulated dry walls,
That, this is the page.
several windows, bath and kitchen
Okay.
upgraded. Right,
But that plan establishes that in 1998, it was under consideration to be connected and converted, but
Okay.
clearly was not.
Right,
And then in 2000, it talks about it
being done.
past
Okay.
tense.
well, I think the thing that's significant about the 2 plans is one says existing sheds, and the other one says,
1-bedroom cottage.
Did you have questions, Mr. McCarthy?
So your distinction between Garabedian and the current case, again, just in summary?
both cases involve a lie.
Well, can I stop you there, just for a sake of, you know, for the Supreme Court, they go back and forth, that it's an inference, I would
Okay.
assume, based on prior documents that suggest knowledge, from which you lead to the conclusion that it was a willful misrepresentation or
Right.
lie.
Okay, willful
Right.
misrepresentation.
Yeah, I mean, I'm just wondering, do we agree on that?
Yes, we do.
Okay.
In Garabedian, the lie was so bald and so over the top that what the court was saying was, well, of course the building inspector knew it was a hangar when he came to look at it and not a barn. And so, because,
Well, let me ask you, for the sake of assumption, when it was constructed, there would have been presumably some inspections, progress inspections, that prior to a certificate of occupancy, if there even was one. So the question is, what was the inspector's take on it as it was going through the progressive,
are you
reviews?
talking about the hangar or this?
The hangar first.
Well, I mean, since I really haven't read the case, and certainly
Sure.
didn't read the lower court decision, just from the chairman's reading, it seems like the Board of Appeals, or the Court of Appeals was saying the lie was too big to be like, oh, we really believe it's a barn. And so they're saying that even though he called it a barn in his application, because the town had knowledge that it was not a barn.
Mr. Chairman, I defer to you since I haven't read the text of it, whether it's more the question that the structure, irrespective of name, existed for a sufficient period versus,
Well, I think it's clear, simply because of the timing, that the structure, the existence of the structure is protected. The question,
we're talking use.
we're talking use, and so, I mean, again, I haven't read the case, but based on what the chairman said, it sounds like he said, it was obvious it was a hangar. And so they're imputing that knowledge, that some staff person had, to the town, saying, you had the knowledge and you didn't take steps during the construction process, so you're bound by the statute.
So it's too late, okay.
Yeah.
All right.
And so the difference here is that the willful misrepresentation established the status of the structure, pre-existing non-conforming one-bedroom cottage. And so when the staff person arrives to see the windows that are being changed, of course, no, it's a one-bedroom cottage. And so there's no way without going back through all this history that we have, there's no way for that staff person from the building commissioner's office to know that it's a lie. So you can't impute the knowledge.
This is just a question for my knowledge, are we attempting to distinguish between a cottage for, say, summer use versus a single-family residence that would permit year-round use
But
with kitchen and related facilities?
the without talking with the building commissioner, I really would not know, but it seems to me that I think, well, I agree, I don't know if everybody else does, that the structure as it exists today is protected. Structure.
Right.
Okay. And so then the question of the use, and I think that's a question really that the building commissioner has to determine. Presumably, at a minimum, the kitchen would have to be removed. So it can't be used as a residence. Whether the bylaw allows like guest quarters to be used out there, I mean, or maybe it could be used, maybe using it as an office, maybe that's the structure is a permitted use. Clearly, storage, because that's how it was used prior to this application. So there are uses remaining to that structure that presumably would be legal, and the decision of this board, should it be favorable to us, would not hinder those uses. And those are, perhaps, Mr. Harrison could respond to a question in that direction, but I just don't know what other uses would be legal there.
Could I just, I don't mean to take up the board's time, but just to continue to switch to the Lord case,
Sure.
the part of it that, and I agree with the chairman's, I forget what your characterization, but it is cryptic, I think, or whatever you said. When it makes reference to the Cape Resorts case in there, with respect to the 6-year limitation on the use, agreed, does not protect a use, automatically by the number of years. But, and if you're looking at the decision, it's page 228, at least how I printed it off the internet, in the paragraph that begins the 6-year limitations period.
Right.
When it gets down to reference after the Cape Resorts versus Falmouth, it says it presaged no change of use. So it suggests that there was nothing in the application there. And in the Lord case, and it goes on to say, the record here does not show that the 66 building permit for the addition contemplated introduction of in that case, 2-family use. And nor by 72 can we said the permit for the garage signaled that 2 families would be using the house. And I didn't see this prior to the last time's hearing, but I have some difficulty with the words contemplated and signaled in that context as it relates to the the application, and without knowing the motivation of the owner and the applicant, whether indeed it was a willful intent to misrepresent, or had in fact the structure been used as a residential use for some time prior to this particular application.
I think the thing that's, illustrates, to the best, we can determine here, the use of the structure, is the fact that the plan prepared by Ryder Wilcox refers to it as existing sheds, and
The first one, anyway, right?
yeah, the first one, right. But also, Pat Ballow's note on the Board of Health refers to converting the sheds to one or two residences. And so presumably, again, inference, I mean, Pat Ballow was a Board of Health agent or an assistant, and so she was out doing inspections and things. I mean, she was on the ground, on the site, and you have to, I think it's a fair inference that she was familiar with the structures.
So really what that does is establish that 15 years ago, it was not, at that time, in use as
Right.
a single-family house
That's correct.
rental.
That's what I think that's a fair,
And she also had that conversation, she references Terry Ryder as the engineer. Pat references Terry Ryder in there, and he drew up the plan that represented those as cottages. So I think it's pretty reasonable that we've got a reputable engineer, and the owner, and the health agent all agreeing that, in fact, we want to see if we can put a septic in big enough so we can develop this stuff, which meant it didn't exist before then.
And the net effect of a decision, what would we be doing, annulling the action of the building commissioner, would be to, assuming it's used, you said it has been used in the last summers by,
Yeah, they're renting
to
it.
cause
Yeah, they
noise.
rent it out as a residence.
and so it would be a reversion to a pre-residential use is what is the
right. Well, they,
upshot?
well, that's correct. I mean,
That's right.
they could, if you think back again to the beginning history here, the initial thing from the planning board was it had to be demolished. They came to the zoning board and asked permission to use it as a storage shed. Because they had, apparently, people had been staying in it, but that was the 60s, A lot of things happened in those days. But but yeah, they could come apply here to use it as a one-bedroom cottage. That would be one avenue for them to pursue. And you can impose whatever conditions, if you saw fit to grant it, you can impose whatever conditions. But what it does is it brings them back into the correct column. In other words, whatever use they use is going to be in conformity with your zoning bylaw, whether it's a grant by you or determination by the building commissioner.
Yeah, to me, since there is, this shed somehow became a one-bedroom cottage, through a process of ownership change. And there's no evidence that the shed warrants being a one-bedroom cottage. It's non-conforming to start with. Now, Ford came down and supported, the building commissioner in the sense that statute of limitations, would prevail. But what we have, I think, to me, appears it's a fraudulent situation. Fraud was committed, along the way, of which the statute does not apply to fraud. That's how I,
Well, then-
finally boil this,
Well, and
all
they-
of this,
And there,
down to,
Yeah.
and therefore, it
Well,
should revert back to a shed.
well, and I don't know where you.
Not even a,
Yeah,
not even a living situation.
I don't know where you practice law, but that's exactly, in the,
Never.
in contract,
But I've dealt with lawyers all my life.
in
You have my
contract,
sympathy.
He beats him up, but he
yeah, it
doesn't.
does a good job too, I'll bet. In contract law, one of the things that beats the statute of limitations is fraud.
And then that's the
Fraud in the,
case.
fraud in the
Hey, that's the
inducement.
case here.
Yeah. So
And, and
It's a good
and
analogy.
maybe perhaps shame on the town, for not picking it up. When the conversion to a cottage, was in process. But it's still, to me, it's still
Well,
a fraudulent situation.
Brian, is there anything in your file that confirms or better clarifies the date at which time it was started to be used in the way it's presently used?
The only thing I have is the information on the building permit, yeah.
From 2000?
Yeah, that's the only thing I would know of that established it as a residence.
Is there anything on the inspection card that would indicate as to,
I've not seen anything. Received the permit around March 6, 2000, he issued a building permit. Limited interior renovations on 3/9/2000.
so there's nothing on there that indicates whether the inspector found that the plumbing or electrical was in fact pre-existing or not?
No, not that I'm aware of.
Are there any further questions of the appealing party? Now I will close the hearing for evidence and open it for discussion. I was principally concerned at the outset, and I agree with you, Mr. Soderstrom, that the owner, present owner, or the previous owner acted with defiance of the 1982 order of this board. The decision was clear, and our predecessors saw fit to emphasize that back building wasn't to be used for anything except shed. I'm thinking that even though I'm incensed and outraged by the conduct of the owners, that the meter on really began to run in the year 2000 or 1998. Here, we see the application for a building permit, which really, maybe it was in ignorance or defiance of the previous decision, but the woman was saying that between 1996 or 1998 and 2000, she really wanted to use this for residential purposes. We know now that she's being taxed on it as being a residence. We have evidence that it's used for summer rental. The question then becomes, it kind of softens, and then since 2000 to now, that's 13 years, she's used it for rental purposes. She said she was gonna, the building inspector knew at that time that it was to be tricked out with plumbing and used for that purpose. She's paid taxes on it. So, the original morality of the situation kind of fizzles, where it was filled with lies and defiance to something which really maybe have been in violation at one time of the zoning bylaw, because it was a separate building used for residential purposes that wasn't supposed to be, but maybe that's become the highest and best use. Then the cases seem to say, well, it shifts it over and says, look, and, you know, you shouldn't be, you've got to come in here and raise the question either before the zoning board or the building commissioner or the Superior Court in a timely way. You can't wait through your own fault or through a series of through inaction by a series of owners who might be abutting and not making that kind of complaint. And the cases seem to say that the intention or statements of misstatements in connection with a building permit don't mean so much anymore, and it's maybe the result may appear to be outrageous, but the statute says that after a particular period of time, your claims objecting to that are barred. Now, we know that this is a use. It's not like building a deck and saying, I'm going to build a 10 by 13 deck, and then building it 4 feet closer to the sideline. That's a different story. We know that that's 6 years and you're done. So, I mean, the neighbor or the neighbors have to complain about it. That's dimensional. Here it's use, and you're given a little bit longer time to object to it, but still, you can't wait forever. So, I'm looking for the sense of the board, given those considerations, that the meter really started to run in the year 2000, and even though the history was very, very clear before that, of what the town expected from McLucky and what he was doing, this woman was kind of upfront about what she intended to do. She was putting in the septic system, telling the Board of Health, I'm not sure of all my plans, but it was out on the table that she was going to use it for residential purposes, happened to rent it eventually, and that's what she followed through. So you may consider those thoughts that I've come around to believe, and when I read the Garabedian case, I think that would have been a better case for Mr. Ford to rely upon, but we still end up with the same result, as harsh as it seems, because the decision is based, as Mr. Harrison's decision, on the simple arithmetic number of years after an event, and not from any moral, upright activity on behalf of a landowner. It's not for us to really to say whether someone took advantage of the situation, but the statute's clear. After a particular period of time, you're entitled to what you were doing. Do we have any other thoughts?
I have a concern, the fact that, the owner has never showed up. And that's the person that I'd like to have under oath, to explain the motive, what happened. Maybe she bought the property, and that was a stipulation that property could be a cottage. I don't know, but certainly, if someone in the real estate business ought to know better.
You would think so.
I really, think it was this came about by deceitful, fraudulent, action.
One way of handling that situation, and I expressed that at the last hearing, that we do not hearing from the landowner herself, that depending on what the sense of the board is, that we could continue this hearing one last time until the middle of January, and I will specifically invite the owner to come in and make her peace with us. Just a thought.
But,
I think that-
but if you,
But-
if we rule, against her, she then has the right to appeal.
Well, Mr. Simon would have the right too.
Pardon?
Mr. Simon has the right if we rule against him.
Yeah.
It would be a statutory appeal at that point, though, right?
That's right, might go to the district court.
Well,
Board
they
got to
usually go
district court
to the
somehow.
Superior Court or Land Court.
Land court,
Yeah.
yeah.
But, Mr. Chairman, just briefly, I think, the one thing I'd like to say, if it's okay, is that you said the meter starts running in either 1998 or 2000. I think that it would also be, that from our point of view, the meter starts to run when the fraud is disclosed. That's when the meter starts to run. But obviously, that's our position.
No, that's true, but the only evidence we have right now is that it was out in the open, Mr. Riley, in 2000 by the application, where the owner is saying, I intend to do this.
Well, no, the owner was saying, I have this.
Right,
I have something that's,
okay, all right. Yes,
So you would distinguish that from what I think is a key part of Lord, where it talks about the contemplation of the introduction of the use.
right. Yeah, they said we have an established use, and we're just changing the windows. I mean, it's completely different than Lord. And it's completely different from Garabedian. I mean, it's,
Well, I guess I'm not in a position of deciding how it fits in with Garabedian, but, the other question, Mr. Chairman, I have is, given the testimony of Mr. Harrison at the last hearing about what was available to him as the record on which to review the application at the time, if I recall, and doesn't directly relate to this case, but if you're similarly limited in what you have, either because of old files being elsewhere or not available or something, are we in danger of setting a precedent of annulling Mr. Harrison's prospective future decisions by taking the view that if he had different facts available to him at the time, that he may have acted differently on the application?
I don't know, I think we're basing our decision mainly on the writings in the application itself. At least I think that's what we could concentrate on. The 13-year-old memory is troublesome.
Okay.
so, one final comment would be that the Cape Resorts Hotel case, I think is distilled down to that the 6-year statute of limitation only applies if the building permit application accurately describes the existing use of the premises. That's what that quote in the Lord case was saying. That it was obvious from the application of the Cape Resorts Hotel that no change of use was intended, contemplated. Here-
Presaged is the word they use.
Right. Here, the application implies that no change of use is contemplated. However, it was a change of use. And that's why the statute does not apply. At least in my opinion.
Mr. Delory, do you have any remarks?
I do. First of all, I'd like to apologize to everybody for being late.
Well, let the record reflect that before you joined the meeting, our time was spent in marking in exhibits for the record. Otherwise, there was no testimony of length or consequence.
Thank you. And I was here in the previous meeting, and I have carefully looked over all the documents, and we received Michael Ford's email to look at. Then furthermore, the Lord this evening. And what I'm finding personally is that because of the legalese and all the precedents and all the cases that are being cited and the what-ifs and all that, it seems to me it's more a legal issue versus a zoning board of appeals issue. And I'm feeling that I'm in a court of law, but I'm not licensed to practice. So I'm even questioning if I should vote on it, period. I'm thinking I should abstain.
Very well.
And just a point of order, Mr. Chairman, since 5 permanent members were sitting, I believe I don't vote in this case.
That was my intention of declaring that Mr. McCarthy, as an associate member of the board, that you would not be voting.
Excuse
And-
me, can I point out that he's the one who was present for the entire hearing? I don't know if that'll make a difference. Mr. Delory did miss 20 minutes with the hearing.
Of last one or this?
The entire
This
hearing,
one.
last one and this one.
Not the last one.
Yeah.
No, I know, but
think-
when you look at both of the
Mm.
hearings,
Mm.
the entire time that was spent on hearing this case,
You've been here for the whole
you've been
thing.
here for the whole
Yeah,
thing.
yeah,
But I think your comments before about
yeah.
there was no detrimental,
As far as I'm ruling that there was no, that Mr. Delory,
I'm just pointing that out in
Yes.
case it might be an issue later.
very well.
that's a good point.
Thank you, Ms. Stewart. So, Mr. Delory would be considering. Mr. Cole, do you want to weigh in?
I think it's certainly troublesome that the landowner isn't here, but I can also see why it's convenient for them not to be here. But it certainly complicates a complicated matter. I think the record clearly states the intentions of the landowner to use that structure as a separate second dwelling on or sometime after 2000. I think the record clearly shows that in 1998 it didn't have plumbing. What isn't clear is at what point in history after 2000 was that use established, right? So pulling a permit that either properly or improperly stated what was supposedly present at that point doesn't establish its use, and in my opinion doesn't start the 10-year clock at that point, and that's one piece that's missing. Furthermore, the Zoning Board of Appeals clearly stated that that structure cannot be used as a dwelling unit. So I think the landowner has the burden of coming back in here to get a special permit to use it as a separate dwelling unit, and that in that case, the statute quite possibly will protect them from using it as a separate dwelling accessory to the main house, but not as a rental unit. So I think the burden is on the landowner to show when that structure, and show some proof to when that structure was first used as a separate rental unit.
So that means that the relief you're suggesting, appropriate relief would be that the decision of the building commissioner be vacated.
I think we have two, and this is just one board member's opinion. I think we have two options, which is to continue the matter and somehow compel the landowner to come forward, or grant the application, vacate the building commissioner's verdict, and then shift the burden again back to the landowner to bring forward an application to do with that structure what they wish to do.
Very well. Mr. Delory, I'm extremely sensitive to your remarks, and I understand that when we are discussing, most of us as laypersons, sophisticated questions based on which statute of limitations should be running under Chapter 48, it's very difficult. But I'm reminding the board that we are a judicial body, and we have the responsibility and must discharge it independently, even though it would be certainly handy or helpful to be able to posit those kind of questions to someone else to give us the guidance. Mr. McCarthy.
Mr. Chairman, a question, if I may have to sort of pull the chair's position on, and most of my practice isn't under 48, but if I read in Lord that the 10-year limitations period protects structural alterations done by the plaintiff without a building permit, and then I read the 6-year limitation provisions to apply in the case where there is a permit. Does that then, do you read the 10-year limitation issue to be precluded in the case where a building permit was issued?
I thought I had separated that out. Earlier today, I had somehow or other ascribed a 10-year statute for use. Mr. Riley suggested there isn't ever a statute. There isn't a statute on, except for the discovery of the illegal use. There isn't a statute whatsoever. So,
Point of order, if I could. The Lord case says that they pulled a building permit, but they didn't disclose that it was going to be an illegal use. And so what the Lord case says is that the building permit issue is not valid, but the 10-year statute had run. So it's like they built something without a building permit. I mean, that's really what Lord says. But they said, but it doesn't, but the statute does not protect the use. And the order of the Lord case was they had to stop using it as a two-family residence. And that's the, see what it says is neither the 66 building permit nor the 72 permit is applicable to use violations if real property's been improved and used in accordance. So, not protect the owner's use as a two-family residence. So, if you're going to apply the 6-year statute, that protects the use as described in the building permit. That's what Lord says. If you're using it in accordance with the permit. And the only distinction we're making today between us and Lord is that Lord asked for something that was legal. And here, they said we already have a non-conforming situation, and all we want to do is change the windows. So, but that's, Anyway, so 6 years, the use under the permit's protected. 10 years, there's no protection under the 10-year statute of use.
Members of the board, I suggest that there's no reason to continue this any further, to invite the landowner, and I propose the following motion. That the decision of the building inspector that the statute of limitation prevents enforcement of the use restriction at 10 Beach Road be vacated. Is there a second?
Second.
Any discussion on the motion?
Could you read it again?
The motion was that the decision of the building inspector that the enforcement of the use restriction was barred by the statute of limitations be vacated.
So you're saying we're going to not abide by
We-
the building
The
commissioner's?
building commissioner,
Okay.
his decision that enforcement of the use restriction, that decision would be vacated. And
What next?
what next is, what, it's up to the landowner. Mr. Cole described that kind of similar to the way you did. It's up to the landowner to make things, to fix things the way she sees fit, or do something.
Does this mean that the current usage, will be vacated too?
What we're just only deciding is that the building commissioner was in error in relying upon the statute of limitations. The building commissioner knows his own responsibilities and duties. He may choose to enforce against the owner the continued usage of that building as a residence.
His letter of October 3rd states that in 2000, when he issued that building permit, he was not aware of some of the documentation from the 80s. So again, I think it all shifts the burden back to the landowner to clean up their own record and puts the burden on them to file an application. And so I assume the course would then be Brian would issue a letter to the landowner. The landowner would have the opportunity to file an application and be heard, and I'm sure there will be attendees at that hearing, unlike today.
But in other words, there was a narrow question. We're deciding this. The motion makes narrowly describes the question as to whether the building inspector was correct in relying upon the statute of limitations. We are not in a position of directing the building inspector to take any kind of enforcement action. That wasn't the nature of this appeal, as far as I could see.
That's correct.
And that's why the motion is the way it is. Is there any further discussion on the motion? No amendments on the motion. Then, do we have a second on the motion? Do we have a second?
Yeah, I second.
Yeah, okay. All those,
Just one question
okay.
on the amendment to the motion. Do we need to clarify the issue that the record is absent a document that establishes the commencement of the use? Or
no, there's no proposed amendment on the table, but the motion is intentionally simple
thank you.
and narrow. All those in favor? Aye. And opposed? Motion carries unanimously.
Thank you very much for
Thank
your
you.
time. And law education.
Is there any further business to come before the meeting? then I'll entertain a motion to adjourn.
Second.
All those in favor? Motion carries unanimously.